Moving on to today's next speaker, we have Mr. Henk Louw from South Africa. We are honored to welcome Mr. Henk Louw, Advocate, High Court of South Africa, and an esteemed figure in the international arbitration community. He holds fellowships with the Chartered Institute of Arbitrators, UK, and the Association of Arbitrators from Southern Africa, and serves as a chairperson of the SIAP South African branch. Mr. Louw is a seasoned arbitrator, mediator, adjudicator, with appointments across leading arbitration institutions, including AFSA, SIAC, LCIA, and Shanghai International Arbitration Center. He also serves as an active judge of the High Court of South Africa, Gauteng Local Division. We cordially invite Mr. Louw to share his expertise on ADR in South Africa and contribute to the richness of today's discussion. Over to you, sir.
Morning. Thank you very much for the invitation. And welcome to all the panelists, to all the participants, arbitrators, mediators, and adjudicators from all over the world. It is indeed an honor to address you today. What I would like to do today is give you a quick overview of where we sit in our arbitral environment within South Africa. And as a starting point, I was reminded last night in a discussion with a colleague from London with reference to the arbitrations and the perceptions on appeals and reviews of the words and the wisdoms of Michael Mustiel, one of the greatest commercial judges and authorities on arbitration in the United Kingdom and probably internationally. And it was the following. Arbitration is a process in which the parties voluntarily agree to pay a lot of money to get the wrong result and live with it. Now, of course, that is opposed to what we find in our environment of civil litigation, where we eventually have the right of appeal. Now, let's go back to South Africa. Within South Africa, we perceive ourselves currently to find arbitration as something which is friendly within our jurisdiction domestically and also internationally. Arbitrations are currently chosen as the process of dispute resolution, it seems, in circumstances where it is legitimately and constitutionally permissible. It is enforced by the courts and dealt with by the courts and recognized by the courts, unless, of course, there are exceptional reasons for not doing so. Now, our arbitration system is based upon the general three pillars, of course. Firstly, the common law and developments, international jurisdiction, international trends. And our common law is mainly based upon the Roman Dutch law and adopted with principles of the English law and English law of arbitration. And of course, where there is conflict between legislation and our common law, our legislation would take precedence. Now, the question then is, what is the basis of our arbitral environment statutorily? Firstly, we have the Domestic Arbitration Act, Act number 42 of 1965, which was created way back when, and there is currently a process with the Department of Justice and the arbitral environment in society and leading academics and participants in the system to rewrite this Arbitration Act to bring it within the current environment of where we are and need to be internationally. Now, our High Court, in terms of domestic arbitrations, do, of course, have a role to play, and that we sit with the powers of assistance, powers of supervision, and powers of intervention. And in very many instances, the Arbitration Act does not direct what is to be done, but creates an environment of various provisions in circumstances where the parties can then also contract out of those in terms of the provisions of the arbitration agreement in existence between them. Currently, we do have a bit of a judicial crisis in South Africa, in that we have an extremely overworked High Court with judges taking a massive workload. And that seems currently to be creating a catalyst for matters to be referred to arbitration. and mediation, to which I will refer a little later. However, the judiciary, and specifically the South Gauteng division of the High Court, which is, in terms of the International Arbitration Act, the division looking after international matters, is supported by an array of acting judges. Now, what we generally do is we make ourselves available for a specific period of time, and then we go in and we assist the judges to allow them to deal with their important case role and very important issues, also arbitral issues. And if they, of course, can't deal with it, then we have experts in our fields that we can make available to assist. Now, our current Domestic Arbitration Act has also been adopted in 3 sub-Saharan Africas, neighboring countries. So we have a wonderful situation where we have a feed across of information from one country to the other. Now, in 2017, on the 20th of December, our International Arbitration Act was promulgated and brought into life. Unfortunately, that act took some 12 years to come to fruition, but it is there now. And since it's been there, South Africa, as an international arbitration venue, has grown and developed exponentially. Initially, there was very little happening, but I understand that currently the caseload dealt with in terms of arbitration, both ad hoc and ministered on the African continent, is to a great degree dealt with by us. The objects of our International Act is of interest. It facilitates arbitration as a method of resolving international disputes. And more importantly, we've adopted the model law, INCITRAL, as a schedule into our Act. And it has proper acceptance, and people deal with it. It's international accepted standard for the resolving of commercial disputes. And we, of course, follow the reports of INCITRAL and also its secretariat, and that is in the Act. We've also adopted the INCITRAL conciliation rules, also as a schedule to our Act, and we facilitate the recognition and enforcement of arbitral awards. And for that purposes, we've also adopted the New York Convention on the recognition and enforcement of arbitral awards 1958 as amended and adopted in Schedule 3 of our Arbitration Act. What we have is a Protection of Investments Act in South Africa of 2015, and that is also the subject to be read with the International Arbitration Act. And our International Arbitration Act, of course, binds our public policies, public bodies within South Africa. Within this environment, South Africa is also a signatory to the New York Convention, but of course, our legislation does not require being a signatory or a participant in exit, unfortunately. Now, again, I've mentioned earlier that our High Court does have problems in its caseloads, specifically the South Gauteng division in Johannesburg, which is the biggest and the fastest growing commercial court in the country. And that commercial court is tasked in terms of the International Arbitration Act to be the default court in dealing with international arbitral disputes in circumstances where the parties have not agreed to another division and the matters are not by agreement referred to other divisions as such. As indicated before, because of the advent of this act, we have developed in leaps and bounds. Now, the question is, do we then have the necessary arbitral institutions to facilitate this process that we have and the development of this process? Now, the answer is an absolute and resounding yes. I'll refer you to 3 arbitral institutions, but in addition to them, there are various other appointing bodies. There's the SAICI appointing body, there's appointing bodies in terms of FIDIC, in terms of JBCC, construction industry, etc. So everything is catered for, but it falls generally under the umbrella of the 3 bodies, and the 3 body rules are used. The first is the Association of Arbitrators. Now, that's our oldest arbitral institution. It was formed in 1979. And initially, it developed into a line where it had to do a lot with construction type disputes, but it is now a general body dealing with all matters to resolve disputes with reference to arbitration, mediation, and appointment of adjudicators. And as such, it deals with matters on an ad hoc basis and it appoints dispute resolvers from its panel of fellows. Now, in order for you to be a fellow, you have to do the courses of the association, properly pass the courses, and I think it's on a 70 or 75% pass rate. You then get invited onto the panel, and of course, depending on your speciality, you are appointed with reference to your panel experience to deal with matters. The association also has adopted various guidelines in the use of artificial intelligence in the arbitration and adjudication environment, and as such, it has also provided very many of its own rules. Now, it has adopted and it uses the International Bar Association rules on the taking of evidence, also with the conflict provisions. It has its own mediation rules, which is something which is of growing importance currently in our environment. And then it has its own rules on the conduct of the arbitrations, the 2021 edition rules, and that's based upon the INCITRAL model law. And it is a very good, very workable international set of rules applied domestically. And of course, it also follows the INCITRAL rules. In addition to its very important function as an appointing body, the Association of Arbitrators also fulfills the role of a training institution, both with reference to domestic and international construction arbitrations, and also deals with the training of mediators and adjudicators, mediation training taking place in conjunction with the Society of Mediators in London. And the web address is on the slide if anybody wishes to have a look at them. The second body is a very exciting body. That is the Arbitration Foundation of Southern Africa, AFSA, generally known, which was established later in 1996. And it was established because of a need in the environment and as a joint venture between business and legal resources and legal individuals and firms and practices to ensure that there's an administered process of confidential dispute resolution, both with reference to domestic and current international disputes, and that goes across the range of mediation, arbitration, adjudication, and related processes. Now, AFSA has a wonderful headquarters in Sandton, Johannesburg, with 4 world-class arbitration facilities, and it has branches in Cape Town, Pretoria, Durban, Mabatu, and also in the Garden Route in South Africa. Now, if one looks at the web address of AFSA and consider what they provide, it provides full domestic arbitration services, both as an ad hoc appointing body, but mostly, more acceptedly, as an administered institution. Then they have a division, AFSA International, created and dealing specifically with reference to issues in terms of the International Arbitration Act, incorporating the INCITRAL model law on commercial international arbitration. As such, it administers its caseload in Sandton through Svetlana Vasilina, the Secretary General of the International Court, and that is an indication, of course, that the International Court is a body created within the environment to ensure that there are compliances with procedural issues, issues within the arbitration, etc. Now, within the AFSA international workload, their participation on a dollar value has grown exponentially, and I think it's now probably the second or the biggest facility in South Africa. And we currently sit, I think, in excess of $50 million a year that's being dealt with. And of interest, a general arbitration of an international nature in 2023 took some 8.2 months from commencement to finalization. And an interesting statistic also is that one matter to the value of 169 million was dealt with and resolved in a period of some 18 months, which I think, considering the litigation process through the High Court system, is marvelous. AFSA, of course, has its own 2021 international rules. It has its court. It has very many court members, some 21 members, and they supervise and administer the resolution of disputes by tribunals and ensuring the performance of the various functions in terms of the rules. Now, the 21 members include Justice Louw, and he was elevated to the Supreme Court of India in 2016, and there he served as a judge for a period of 6 years. Very valuable, great member of our court, and has at all times a great assistance, knowledge base, and experience that he provides to us. Of course, we have in our region, in the Southern Africa region, a thing called the Southern African Development Community. Now, that community consists of 16 countries, and it's a regional socio-economic cooperation and integration area, taking into consideration political and security cooperations in the 16 countries. In alphabetical order are Angola, Botswana, Comoros, the Democratic Republic of Congo, Eswatini, Lesotho, Madagascar, Malawi, Mauritius, Mozambique, Namibia, Seychelles, South Africa, Tanzania, Zambia, and Zimbabwe. Now, this development community that we sit in assists and deals with very many issues, and has a extremely big dollar ratio trade zone. I think it's some $600 billion at some point in time. And of course, within this area, we have a free trade zone, free trade area, and we have implementation of the protocol of trade in 2000. Seems to me the slides on the screen may just be a little bit behind mine. Then AFSA also has what they call AFSA construction, dealing with the construction industry. And there they have both administered and ad hoc rules. It has also a thing called AFSA business rescue, AFSA mediation, AFSA training in association with the University of Pretoria. There's also AFSA municipal division, and I'll get to the next one now. Now, in terms of AFSA mediation, the important issue there is our current environment in the High Court litigation and matters in the High Court not progressing. And therefore, we have the mediation facility, and I'll refer your attention to that now. AFSA training, of course, from the University of Pretoria. And once you've done the AFSA courses, you have something akin to a university diploma. Then we have the China-Africa Joint Arbitration Center in Johannesburg. Now, the interesting thing about this is the need for arbitration because of the increase in trade between South Africa and China, and the forum on the China-Africa cooperation, and there were some 51 states to that. Now, KJAC offers party neutrality, speedy resolution, confidentiality, flexibility, etc. And in that process, we've created the KJAC rules on international dispute resolution. Now, those rules are, of course, also on the website of AFSA, and I've also indicated the website reference to KJAC. Now, AFSA has also placed itself in a very interesting situation with reference to the AFSA rules in terms of BRICS and the BRICS dispute resolution framework in existence. If you can just go further down on the slides, please. Now, at the 6th BRICS Legal Forum, which was held in October of 2019, AFSA was appointed as the BRICS dispute resolution in South Africa, and there was, of course, also a call for the creation of various BRICS resolution centers within the BRICS nations and the BRICS member states. Now, the AFSA KJAC rules, AFSA international rules, are now used, it seems, as the basis rules for BRICS. And during 2023, at the 8th BRICS Legal Forum in South Africa, in Kempton Park, those rules were adopted as modified AFSA rules in the BRICS Forum, and my understanding is that it's now been adopted in Russia. Now, AFSA as an institution has also been awarded full membership of the International Federation of Commercial Arbitration Institutions, and I've provided you also with the reference, website reference of AFSA arbitration.co.za for interest. The third is the Chartered Institute of Arbitrators, South Africa branch, and we also refer to indicate that it's Southern Africa. Now, I'm fortunate enough to be the current chair of this organization, and we're trying to develop and grow it, and through formal and informal partnerships, also with various arbitral institutions and the other appointing and non-appointing bodies. Of course, with that, we have access to our 17,000 members internationally, and I think it's the 54 branches and jurisdictions in which we sit. And of course, with that, we present to our environment the Chartered Institute rules, expedited rules, again, importantly, the mediation rules, dispute board rules, which is of great importance in our adjudication environment, and also the various contract clauses in dispute resolution. Our current branch now fulfills the role of an ad hoc appointing institution with reference to both arbitrations, mediations, and adjudications. And we are developing into the Southern African SADC region with the same perspective of AFSA to ensure that we have rules and an environment within our 16-state region to ensure that there's uniformity, acceptance of standard rules, and the acceptance of judgments dealing with the matters, etc. Then, with reference to arbitration in South Africa and Africa, we have arbitration centers, which is recognized, and I think AFSA is currently seen as the premier arbitration center in terms of the 2020 arbitration global review in Africa. And we also seem to be in the second, share the first position in the Cairo Regional Center for International Commercial Arbitration. And we also hold the first place in Africa in terms of ad hoc arbitrations. Of course, that the 2020 report has sterling views on South Africa in terms of its environment, its business environment, its infrastructure, the class of arbitration facilities, arbitrators, etc., that one can use. Now, what does our courts think of us in terms of the arbitration environment? And there I'd like to refer to two issues. That's the first is the party autonomy and the choice of arbitration as a dispute resolution mechanism. Now, footnote 2, you'll see that I've attached the matter of Mafuni, Mohapi and Associates with Andrew and his brother, which was in the Constitutional Court in South Africa in 2009, Volume 6. Now, with reference to that matter in paragraph 34 of it, the Constitutional Court has expressed certain views, and they think that parties have not waived rights not to participate in terms of litigation in the High Court in terms of Section 34 of the Constitution, but the parties have now elected to participate and have their disputes resolved by way of arbitration, and that the Constitution accepts, and the parties can do so. In paragraph 235 of that judgment, I've also indicated the underlying portions that the values of the South African Constitution will not necessarily be best served by interpreting Section 33 of the Constitution, that's the access to courts in the system, in a manner that enhances the powers of the courts to set aside private arbitration awards. Indeed, the contrary seems to be the case. International and comparative law considers in this judgment suggests that the court should be careful of not undermining the achievement of the goals of private arbitration by enlarging the powers of scrutiny imprudently. Now, in terms of our Arbitration Act, there are limited powers of interference, that's procedural irregularities within the tribunal, etc. But it's not an inquiry into the merits of the case, and it's not an appeal provision. Now, the second one is the issue of competence. And there I've referred you to the Supreme Court of Appeal in the matter of Canton Trading versus Fantini Becker, which is the leading issue on this matter. And I've underlined the portion in paragraph 35 of importance. But even if the dispute has not been referred to arbitration, the court may be disinclined to decide the question of jurisdiction unless the arbitration agreement is manifestly void. So effectively what we have is a situation where the courts have given effect to party autonomy, and the courts have said that the arbitrators must deal with their issues as they deal with it in terms of the accept of inquiries into jurisdiction. And if it then goes before a court, of course, at a later stage, then the court can deal with it, giving effect to the issues of party autonomy. And of course, the importance of it also referred to in paragraph 37 of reference to the matter of Zondi. Our courts are giving effect to the enforcement of arbitration agreements. Now, within that environment, we find that our courts have accepted arbitration as a proper dispute resolution mechanism, and it gives absolute credence to it. And there's currently a situation in our jurisdiction where it seems to me that courts are wanting matters to be dealt with by way of dispute resolution, and that is by way of mediation and arbitration. And of course, we have our courts involved in both international arbitration as well, and with reference to the model law, there are various issues in which the courts are involved. And I've referred you in the presentation to the provisions of the model law and what the courts can or can't do, but that's in terms of the internationally accepted standards. And I've referred you to the various articles in it. Now, where do we find ourselves in the High Court currently? And I'm now probably at the second or third last page of my presentation, the South African High Court, especially the South Gauteng Division, which is fairly congested. We have the following situation. If you now set a matter down for a hearing, you're going to wait until 2031 to get a court date for your matter to be heard. Our Deputy Chief Justice, Roland Sutherland, has commenced with the marvelous process of following what is also happening in the United Kingdom in the matter of James Churchill, which I referred to in footnote 7 of my presentation, to say that matters must now go for mandatory mediation. And if they can't resolve by way of mandatory mediation, they can come back onto the roll. But all matters from 2026 end and further have lost their placing on the roll. And if you haven't gone through mediation, you can't have your matter placed back on the roll. Now, in addition to that, what we're creating now is the second process, also by changing the rules of court, by saying, let's take matters out of the High Court roll and divert them to arbitration completely. And once they are in the process of arbitration, they are, of course, off the system, and they're dealt with by way of party autonomy and agreement between the parties. And once we give the parties the ability to make an election whether they want to go into private arbitration, the parties to the dispute will sign a form document, and the form document contains an arbitration clause. And once it's been signed by both parties independently, of course, they can arbitrate. Now, in the event of a dispute becoming before a court, that would then create a bottleneck again in terms of the review, in terms of enforcement, in terms of applications to have arbitrators removed, etc. And how do we deal with that bottleneck? And of course, the appointment of arbitrators when the agreement doesn't provide them. We further propose that we change our commercial court structure in South Africa. We create an arbitral division, and within that division, we create very strict timelines for matters to be heard. And once the matter is trial ready to be heard, which should take about 2 months, then we can have, we want a judge appointed. And in the event that the system doesn't have judges because it's so overworked, then we as the profession propose to make individuals of the profession available to assist the High Court, and we then act on an ad hoc basis to assist. Now, that process is currently under discussion, negotiation, and review, and hopefully if we have a further session at some point in time, we can positively say something about that. Then in terms of my last slide, because of the importance of private dispute resolution and the acceptance of the process, we, and being advised by colleagues also in London, are now doing away with the term alternative dispute resolution. We are now using it exclusively as dispute resolution, because we see dispute resolution as an absolute equivalent parallel. It is cost effective, it is time efficient, and it is not subservient. And in a presentation a couple of weeks ago with an actuary, we unpacked the whole process as to cost of arbitration, And we've worked out, depending on the quantum and depending on how long it's going to take and the time value of money and inflation, it is cheaper in the long run to arbitrate and pay an arbitrator than to take ourselves into the high court system. With that, thank you very much for the presentation and the opportunity. It's much appreciated.
Thank you, Henk, for illustrative the guidelines as set out in SIAB, the way how the South African context on domestic and international arbitration, along with that the AFSA and the other institutions in South Africa facilitating the arbitration in the way how it has to be. And we are very happy on behalf of KFCRI to thank you. Within a short notice, you have accepted and you have come forward to share with an excellent presentation. A PPT is so elaborative, and thanks for it. And already you got the chat from Dato Mary Lim on this very unique time wherein very interesting personality is going to continue with this conversation on this Global South ADR THIRUNAAL. Thank you, Henk.
Thank you for a wonderful, wonderful idea and this great knowledge sharing from across the globe. It is really appreciated. Thank you.